The reason why I didn't sign the order on an ex parte basis is it included some language about the court making some findings. Previously determined that Kimberly Dobson made the fraudulent conveyance.
What I was asking the court to address was, again, more fraudulent transferred by Mrs. Dobson. Every vehicle, machinery, ORV, UTV, whatever is in her name was purchased with all of W. Whitetail's money. So we were asking to seize those items just because title might be in her name. He's used this 5 months basically to liquidate the other account that I pointed out. And now on the day of bankruptcy filing, they removed 135 grand of that, and now it's disappeared. It's gone.
All right. So we got a motion up by plaintiffs here, and then we have also have the set for a debtor exam today. So counsel, how did you want to?
So Judge, we did have the debtor's exam set for 1 o'clock. I was really interested in the documents that I had requested. Unfortunately, the debtors, or the defendant and Mrs. Dobson, provided me 4 documents, which are actually 3 documents, two printouts from Huntington National Bank and a copy of a receipt for some fee dated June 29th, 2026. So none of the other documents I requested were produced. No titles, no bank records, nothing else. So I don't know that there's a whole lot I can ask them without the documents. And I don't know how the court wants to address their failure to produce them.
Okay. Ms. Honig, do you have any explanation for that?
Your Honor, my client's June bank statements have not been received yet, and that would be why he hasn't turned those over as far as the titles. Mrs. Dobson had indicated she didn't have any because they have liens, but it's possible they just are in a box and not unpacked. My client could certainly go to the Secretary of State office to request duplicate titles, but we need time to do that.
All right. Why wasn't that done by today? I mean, today's the day, right?
I understand my client did not receive the subpoena until a week ago, and it was a holiday weekend, so it would have been difficult to get that info by today.
All right. What other information was there that you had?
Well, there's quite a bit of information, Judge, that I saw. Give me 1 second in terms of the debtor's exams. All monthly bank statements related to the Huntington National Bank account since January 26th of 2026. So they should have those that have been provided. Copies of deposits since that same period of time. Bank records for WD Whitetails from June 1 through June 30th. Again, there are no WD Whitetails bank records here at all, including bank deposits, canceled checks. Produce all negotiated checks, front and back, copies of deposits from January 1 of 2026 through January 30th of 2026 for any DDR account. I don't know if DDR of Lake exists or not. Produce any and all documents related to WD Whitetails merchant credit account that exists, including the Square account and all monthly statements since January 1 of 2024. And I would indicate to the court, these documents are also requested in the bankruptcy case. So they've known about this for quite some time, and they didn't produce them back in June when they appeared at Mr. Pushkar's office for deposition, and they haven't produced them today. Copies of any and all applications for credit that Mrs. Dobson has made since January 1 of 2024. Copies of all titles or documents of ownership, purchase documents for any vehicle, motorcycle, ORV, UTV, four-wheeler, tractor, motors, farm equipment, construction equipment, and associated implements located on the real property, which is property that we're talking about here, which is the Vernon Lake property, as well as a list of any and all personal property of any nature you claim that you own, which is located on the real property, identified in Exhibit B, which is the parcels of real estate that is currently under the name of WD Whitetails. None of that's been produced. So we don't know we have no idea what Mrs. Dobson claims is her personal property. We have no idea what Mr. Dobson claims is his personal property. And that is consistent with my request to go out and reseize items that are out on the property, because the prior seizure order expires 90 days after it's signed by the sheriff. So as part of that, I was requesting that information so we knew that we were going to see certain personal property, but we don't have any of those documents.
Okay.
And I don't know when they're going to be produced.
Your Honor, the property that was seized has never been returned to my client. The personal property is still in possession of the court officers. So, and it's my understanding, order to seize property, as long as it's executed on time, would not be expired because the property was seized within 2 days of the issue of the writ. And it's still not in my client's possession. It's not at the real property. It's in the possession of the court officers that took the property. If the plaintiff wants to liquidate that property, I don't think anything actually stops them from doing that without a receivership being ordered.
Okay, what about the documents though?
With the documents, other than the June statements, my client believes he turned over all the Double D Whitetails bank statements, which is a bank account at Isabel Bank. There are no double or DDR Lake bank accounts to turn over. I don't know what to say about Mrs. Dobson's applications for credit. I'm not familiar with that at all.
Yeah, there were a lot of other things I've mentioned.
I don't have an explanation for the other things he mentioned. I just know the bank statements up through May for Double D Whitetails were turned over, but the June statement has not been received by my client yet. So he does not have a copy to turn over. He can certainly turn that over as soon as he has that. And with the copies of titles, they will either need to locate them or obtain them from the Secretary of State. That is all, Your Honor.
Okay. All right. Counsel, moving on away from that issue for a moment and directly onto your motion for today. The reason why I didn't sign the order on an ex parte basis is it included some language about the court making some findings regarding Ms. Dobson. And in particular, the court having previously determined that Kimberly Dobson made a fraudulent conveyance to Edar Lake. So, I'm not sure that I ever made that kind of finding. So that's when I saw that language, that's what concerned me in particular about the order. Can you tell me, is that something that the court would be making an implicit finding of based on entering the order and granting the relief that you're requesting?
The relief that I was seeking in that particular order, Judge, was related to your order that got entered. It looks like it got entered in March. That related to the finding of the fraudulent conveyance. So that order, we've already recorded that order. So that part of it is done, and that's been recorded with the Register of Deeds office. So that part of it is complete. What I was asking the court to address was, again, more fraudulent transferred by Mrs. Dobson to herself and trying to lay out kind of what that was, which is what we determined in the bankruptcy case. If you go through her testimony and some of the things that I've indicated there, every vehicle, machinery, ORV, UTV, whatever is in her name was purchased with all of W. Whitetail's money. Not a single item was purchased with any money that she possessed. So we were asking to seize those items just because title might be in her name. We should still be able to recover those as fraudulent conveyance. And my suggestion was, let's get them seized first. If she's going to bring in documents to show that she has title or that she contributed in any way to the payment of that asset, she can bring that in. That's why I asked for documentation from her again as to the titles. She didn't bring them. I don't know which ones are in her name. Some of them are like a UTV will only have a certificate of origin. So you need to have that document to know who actually owns it. And some of that stuff was not seized when the sheriffs went out. They particularly asked him, what do you need to continue to operate? My understanding from what their explanation that they provided to me, Mr. Jesniak, they talked to Dennis, they asked him what you needed to operate, and they left stuff there. So even though technically they could have seized it, they didn't want to leave him in a position where he couldn't operate and take care of the deer there on the farm. So that stuff was left. We are now in a situation where, following the bankruptcy court's determination and the bankruptcy filing, I've been sitting here for 5 months. He's not operating. He's not doing anything to operate the business. He's not taking any deposits. He's not doing any hunts. He's not selling any deer. He's used this 5 months basically to liquidate the other account that I pointed out, which was a $200,000 deposit into Bayport State Bank. And now, on the day of bankruptcy filing, they removed 135 grand of that, and now it's disappeared. It's gone. And we during the depositions, we asked for an explanation. We don't keep receipts. I can't tell you what we spent it on. I have one CD, which again, Mrs. Dobson lied about, and then finally fessed up. She had possession of it. She was supposed to produce it. It's still not here. We don't know if that's spent as well. So all that money that is Double D Whitetails money is also gone. So that's my alternate request is, Judge, I think we're at the point where we got it. We have to have a receiver under Revised Judicature Act, and we need to get them out of the house. Things are just going to keep disappearing. The bankruptcy, pretty rare for you to see a judge make a finding of bad faith and bar somebody for 2 years for refiling, but that's what he did in this case. And now they're basically here before you, and this will be your case until they can figure out something else. And, you know, I don't know many receivers up in this area, but certainly my client has a suggestion of a couple farmers that would come in and at least take over the operations and determine what we do next. The bidder that's here, he has a different perception about what this transaction would include. His offer is $1 million, includes the land. The other 4 parcels that are not part of the land that has a lien of the bank on it, as well as all the equipment that was seized. So his understanding is a little bit different, and I don't know that that's going to be a legitimate offer, considering the fact that only one parcel was appraised for $1.25 million. They didn't appraise any of the other parcels, and they didn't appraise the equipment when the bank loaned the Dobson's money. So we believe, and again, based upon Mr. Dobson's own statement, that Double D Whitetails and the farm could be anywhere between $1.5 and $2.5 million of value. Certainly, my client would rather see that result come to fruition, if that's possible. And that's why I attached the signed personal net worth statement that Mr. Dobson provided to Isabella Bank when he got the loan. So his bankruptcy petition is something totally different than that. Shows a value of $59,000 versus $2.5 million. So clearly there are issues here about fraudulent transfers by spouse, activities by the debtor or by the defendant, Mr. Dobson. And I believe that the receiver is absolutely going to be required in this situation, and sooner rather than later.
All right. And it's your view that taking that action now is going to preserve these assets for potential distribution and allow for issues like whether Ms. Dobson has an ownership interest or how that relates to what your client may be able to attach as part of their collections.
Correct, Judge. And
But it keeps everything in one place so that can be worked out.
That can be worked out. And I can tell the court right now, again, representing what was testified to, Mr. Dobson was going to make the June payment to the bank. Now he's not going to make the payment to the bank unless you let him stay there. The taxes are a year past due. The insurance doesn't even have the correct loss payee on it. So there's a lot of things that need to be cleaned up. And I know the bank wants to make sure that they're secure. I have spoken with Mr. Pushkar. We have agreed to enter a stipulation if it's acceptable to the court that just simply indicates that the bank holds a first priority position over my client's lien on the property when you granted the order setting aside the transaction. And I don't know if the court's willing to do that or not, but it grants them a first position in the property rather than leaving some question about whether or not they have a first position or not. And that has to do with the order that you entered, basically setting aside the transaction. They're concerned that DDR of Lake, now their borrower, is not the owner of the property. But my client's agreed to a stipulation with the bank. And we can enter that if the court's okay with that, or the court wants a separate motion, we can address it at that time as well.
All right. Thank you, Ms. Holman.
Your Honor, my client's position is this $135,000 reference was never actually money that belonged to Double D Whitetails. It was from the sale of the house he and his wife sold in Kindy, Michigan. And that was the remaining proceeds, which were deposited in the Double D Whitetails account because they did not have another account at the time to deposit it. Also, the monthly expenses for the property did not cease to exist upon filing the bankruptcy. They still have the deer and other animals on the property that have to be cared for, and there's monthly expenses like utilities, etc., which are stated on the schedule INJ that I attached to my opposition to this motion. And the property is my client's primary residence, regardless of whether it's Double D Whitetails or DDR Lake that owns the property. They have been living there since they moved from the Kindy property, and ordering immediate possession of their residence is an extreme measure and not necessary. They are not destroying the property. If the plaintiff needs possession of the personal property located at the real property, that doesn't really stop my clients from being able to live in the residence at the same time. Also, when the personal property was seized back in January, my client's position is he was not asked what he needed to operate. He was asked which property was owned by him personally versus not owned by him personally. And the property owned by him was seized, whereas property owned by Mrs. Dobson was not seized. And they were not able to operate without that property. It was never returned, despite the filing of the bankruptcy, which is why they were not in operation. And the bulk of the income for Double D Whitetails is in the fall when hunts take place. And normally, yes, my client would start taking deposits now, but if he doesn't know that he will be operating in the fall, it would be bad faith to take deposits without being able to provide the service people are paying for. Nothing further, Your Honor.
Great. Counsel, on the issue of taking possession of the real property and essentially evicting the Dobsons from that, what's your position? I mean, is that part of it, a necessary step here? Because I mean, I tend to agree with Ms. Honig. That is a rather extreme measure. It's not one I've seen.
Judge, while it may be extreme, the problem we have is that we have a lot of activity going on that's detrimental to the preservation of that property. And there's no way for us to go in, even if we get a receiver. They've not been cooperative in anything that I've done in the bankruptcy or in this case so far. We're not going to be able to get a seller to be able to go through and look at the property, determine, or a receiver, what they would be willing to pay if the Dobsons are present. And if they're not operating the farm, certainly don't want them caring for the animals. They're not going to get the animals at any point in time. Certainly they'll be my clients or whoever buys the parcel there. Does my client trust them to take care of them? No. Doesn't.
What you're saying is what's happening on that property from day to day in terms of the maintenance of the property itself and the contents and the animals is directly related to the value potentially to a buyer.
Yeah. The only way that there's extra value, and here's if you're actually conducting hunts, he doesn't want to do that. He hasn't done that for 6 months. Not sure why he filed a bankruptcy if he had no intention of taking deposits. And he hasn't taken, there's been no activity in his account. He's taken one deposit. He conducted one hunt pursuant to his prior testimony. That's it. They're not holding a foundation event, which normally they would hold in June. That's not being done this year. That's where they get a majority of their hunts. And I believe last year they received 150 grand from the foundation related to hunts. So that income won't be there. And at some point, I don't know if the animals are being taken care of. There's no way to know that. They have no employees. There was no third parties, my understanding, based upon their prior testimony. It's only them. And if they have 135 grand or they spend a portion of it, certainly they have the ability to obtain another residence because we're probably never going to see that money. That money will be gone, or it is gone. And I don't know where it went. So in since February 13th of 2026, they can't tell me what they spent the money on. So in 4 months period of time, got no names, no individuals. I've got a couple food receipts and that's it. It's all, other than that, it's all been dispersed.
All right, I need a minute. I'll be right back. Okay, we're back on the record. Prior to the hearing today, I did have a chance to review the written submissions of the parties. I also had a chance to consider the arguments of counsel here on the record today. First of all, turning initially to the plaintiff's motion to seize assets and to appoint a receiver. Looking at that motion and the basis for it, again, I did have a chance to review that. I reviewed the supporting documentation that was provided, including the deposition testimony of Ms. Dobson. The court finds that, number one, there is a basis to grant the relief requested in terms of the seizure of the property, as well as the appointment of a receiver pursuant to MCL 600.6104. First of all, in reading the testimony of Ms. Dobson, certainly troubling testimony. It does appear based on that to me that assets have been moved around, that assets are missing or have been expended. That, as counsel referenced today, there was, I think it was a $25,000 CD that she stated she didn't know where it was, or it was in a safe deposit box, and then stated that she actually had physical possession of it. I found her testimony to be generally vague and just generally troubling. And that, in addition to what I view have already been efforts during the pendency and subsequent proceedings in this case to delay proceedings, to hide assets, to prevent collection. The bankruptcy filing itself, which, given the outcome of that, I find to be a troubling development, and certainly one that gives the court cause to believe that the defendants are looking for any way to prevent collection here. All of those things, to me, combine to provide good cause for appointment of a receiver and an order to seize assets, if nothing else, to preserve the status quo until questions, to the extent there are questions regarding ownership of certain assets and entitlement to certain assets, can be resolved before those assets, again, are dissipated, lost, or transferred and unable to be recovered. I also believe, although I agree that it is an extreme step to essentially evict the defendants from the property, in my view, this is more than just the standard case where there are concerns about waste or damage to real property during the period of collections. Based on my prior knowledge of this case and counsel's statements for the record here, I'm satisfied that a significant part of the value of this real property is tied to its operation as a ranch, and that if it's not properly operated, that a significant portion of that value could be lost or dissipated. So this is a unique property under unique circumstances that I think call for a unique order here to preserve the value of that. So all of that to say, the court is granting the relief requested. In terms of the appointment of the receiver, the court is going to request that plaintiff's counsel submit to the court proposed receiver with all the information contemplated under 2.622B1, along with a proposed order of appointment that would contain all the information required under 2.622 so that the court can properly consider that receiver and have that process get started. And counsel, you may have submitted a prior order. I'm just going to ask that you submit a clean order. I've got orders and all kinds of attachments here in the file. So I'll ask that you submit that order. And then dealing with the debtor's exam portion of this, the court is going to allow 30 days, Mr. Dobson, for you to comply with the subpoena. To the extent that there hasn't been compliance, then I'll just ask plaintiff's counsel to issue a show cause on that. Mr. Dobson, I'll just indicate for the record that failure to comply with subpoena ordered by the court is punishable by contempt. And that means that you could be ordered to pay fines. You could be incarcerated as a measure to compel your compliance, and you could be incarcerated until you do produce those documents. And you've had lots of time to take care of this. To the extent that there isn't compliance within the next 30 days, the court will consider all possible punitive as well as compulsory sanctions for contempt. So we're going to move this thing along. I'm not going to take any more time. So things need to be complied with. Orders and subpoenas need to be complied with. Mr. Beadle, anything further?
Yeah, Judge, just for one clarification, actually, there was a subpoena for Mr. Dobson and Mrs. Dobson as well.
Correct.
I
Both.
just want to make sure it pertained to both.
Yeah, I don't know if she's here or not.
She's here. She's right behind Mr.
So,
Dobson.
I mean, that the contempt sanctions apply to court orders in general, whoever they're directing.
Okay. I'll do a separate order on that provides that issue.
Correct. Okay.
And that's 30 days from today?
Correct.
Okay. Thank you, Your Honor.
All right. Thank you. That's all for.
I guess I had one question. Does the court want me to motion up the issue with regard to the Isabella Bank mortgage? Or how do you want me to address
Thank you.
that?
I did not have that one in my notes.
It was not, we didn't present it to you. I just talked to counsel and he wanted some clarification and it relates to your order. And his client is concerned that somehow he doesn't want that order interpreted to say that mortgage is no longer valid.
I can provide a little color on this, Your Honor, if possible. So Isabella Bank came in at the beginning of January 2025 and provided mortgage funding on one of these parcels to pay off an existing land contract. So there was land contract owed. Isabella Bank provided, I think it was roughly $500,000 that went right to the land contract folks to clear that. And then the Isabella Bank debt came in. At that time, the property was owned by Double D Whitetails and then transferred to this third party DDR of Lake. So my mortgage is in the name of DDR of Lake with guarantees. And the court previously decided that the transfer from Double D Whitetails to DDR of Lake was void. Under the Uniform Fraudulent Transfer Act or the Uniform Voidable Transactions Act, you know, when a party comes in good faith and lends for equivalent value, the mortgage remains. It's not stripped. But looking at the language of the order, I just wanted clarification in the chain of title. Should we have to foreclose, that wasn't going to be an issue. I've talked to Mr. Beadle at length about this, and we've agreed on a language in an order that we could record that would clarify that. But that's the whole reason I'm here. And so just looking procedurally on how best to go about that.
Soning, do you have any position on that?
Your Honor, my client has no opposition to Isabella Bank retaining their lien against the property since they were since he was the borrower as well as his wife, along with DDR Blake. That was the intent for that mortgage to be against the property.
Then I don't have an objection to that as a stipulation between.
Okay,
very good.
If you want to submit that with both orders.
I will, Judge. Thank you.
Thank you so much, Your Honor.
Thank you.
Your Honor, just to clarify, the possession of my client's residence is immediate, or?
As soon as the order is signed, then yes.
Thank you, Your Honor.
Thank you, all right.
Do you guys need to,
Just don't take what everybody's waiting for.
Mr. Dobson, you're going to need to go with the officers here too before you leave today.
Okay.
Apparently they're for warrant for you.